Mr. Chair, members of the committee, thank you very much for hearing Senate Bill 28. Senate Bill 28 is a bill that changes the definition of misconduct in relationship to the unemployment benefits. What's happened over the last few years is our courts have liberally construed our current definition of misconduct in a situation where people are getting benefits for things that after being terminated for what I would say is good cause or misconduct. Let me go through a couple of these cases so you understand them. Repeatedly falling asleep on the job, urinating off the top of a school building while school was in session, violently clearing off a filing cabinet after being reprimanded, continuing absenteeism beyond company policy, using profanity in front of school children, and stealing being caught on camera. All these individuals received unemployment benefits. I think when you hear some of these cases, it's very obvious that we need to do something to change what our current statute has for misconduct. So we went and did some research. Well, working with the Missouri Chamber, we found that Florida changed their definition. So Florida had a similar definition as ours before, and they changed theirs to this. It seems to be working. We're going away from a willful or wanton to a knowing disregard. I'll be glad to try to answer any questions. I know we do have several members here to testify in favor.
Are there members of the committee with questions for the bill handler? Madam Hearing, would you bring your first witness?
Yes, I'd like to call Tracy King with Missouri Chamber.
Thank you.
Mr. Chairman, members of the committee, Tracy King here representing the Missouri Chamber of Commerce and Industry, and we'd like to go on record to testify in support of Senate Bill 28. We began working with Senator Krause on this issue beginning late last session after we had been receiving numerous calls from our members who were very concerned about some of the recent decisions on the unemployment insurance claims that were coming down, not just from the department but also from the courts. And so what we did is we began looking at the prior year or two's decisions that came down and going through this stack of, I kid you not, about this tall, looking at those claims. And what we found out is that our definition of misconduct is set so high that it's almost impossible for an employer to actually prove misconduct. You have to prove that they consciously did it, and they have to prove that they intentionally did it. And so in most cases, if you say that you didn't intend to do it, then the courts have ruled then that it was not misconduct. So we began looking at what other states have done. Our definition of misconduct was kind of a model national language back when unemployment was first brought in, and we had not changed that statute since the beginning of the unemployment insurance when it was first put in. What we've seen is that Florida, in response to what we did 2 years ago in reducing the number of weeks, took a look at their unemployment and made some changes. And the changes that they made were to the definition of misconduct, almost similar to what we proposed with some minor changes to make sure that the definition actually fit our statutes. And since they were able to do that, they were able to bring down the amount of their deficit to their unemployment insurance trust fund significantly. So it's been a rally cry for the employers. It's been something that they in Florida have seen as true reform and has been very helpful. I think it's important that we do that. Also, our unemployment insurance trust fund is just shy of $600 million insolvent. So employers have seen a tax increase over the last 2 years through the repayment mechanism that we have with the federal government. That is increasing. In 2011, it started at $21 an employee. The employers got notice in November and had to start paying it in January. And so they didn't have time to plan and budget for that increase. Back in November of 2012, they received another notice that it was going to go up another $21. And that will continue through our projections until 2015. And at that point, it'll be, I believe, $84 an employee. So this is significant for our employers, and what it means for many of them is the difference of actually hiring employees or not and keeping the doors open a lot of times. And so we ask that we maintain the integrity of the program. And you heard some of the examples that was given by Senator Krause. These are just a handful of several examples. We've got one recently that came down that had to do with, there were a couple of instances or a couple of scenarios in the case, but a truck driver who tested positive for cocaine and was able to get unemployment benefits. So, you know, we think this is very important. I will say that the bill moved through the Senate 28-2, so it got bipartisan support. There was an amendment that was requested by the department and also by the minority leader. We made those changes to ensure that any activity outside of the workplace had to be related to the work. And so those changes were made, and so we think it's a better bill because of that, and so we ask you for your support.
Thank you. Are there questions for the witness? Representative Hampton.
To inquire.
Go ahead.
Thank you. Good morning.
Good morning.
Could you give me some numbers so I can get my arms around it a little bit? I hear this from employers quite frequently that an employee has gone out of the bounds and they have been terminated and they have applied for unemployment benefits itself. The employer has appealed the decision only to be turned down on that. Do we have a percent or a number of these cases that were overruled and overturned and the employee received the...
I don't have that number, but I know that the Senate Government Accountability Committee last year talked to the department, had them come up and talk about how many appeals were returned in favor of the employee versus the employer. And I know they're here. I don't know if they have the numbers, but I can give that to the committee. I will say, in looking at the problem, it's not necessarily with the Department of Labor, because when the circuit court rules that an employer, like falling asleep on the job, isn't intentional, because you don't ever mean to fall asleep on the job, and it doesn't matter if you're, and in this case it was a person who was in charge for a Alzheimer's unit in the middle of the night, and that could have been devastating had something terrible have happened. But falling asleep on the job isn't something that you actually intend to do. It's unintentional. You fall asleep, and so a lot of these decisions, when they're made, the department actually has to follow up with those decisions. So, a long answer to your question is I don't have that. I know that a department does. I don't know that if it leans one way or the other, and I think a reason for that is because of the fact that the definition for misconduct has been eroded by court decisions throughout the year.
But you would agree that through the overruling and appeal process itself, it's continuing to drive the cost in the upper position? Absolutely,
absolutely. Yeah, I mean, basically, if you go in and appeal a decision, if the employee says, I didn't intend to do it, most of the time, the department will rule, or the courts will rule, that that the employer has to pay unemployee benefits. Another issue deals with voluntary quit, and I don't think we address that in here, but we probably need to look at that for future purposes. But the courts have also ruled that if somebody leaves, let's say they want to take a vacation time and you tell them you can't, an employer says you can't leave, you've got to be here and work Friday and Saturday. If they do take the vacation time and leave and come back 3, 4, 5 days later and say, I want to work, as long as they say I'm willing to work and they're there to work, you don't have to hire them, but you do have to pay them unemployment. And so that's another area that we need to fix. We're really focusing this as a one step, and really like to spend some time over the interim and looking at how else we can improve the unemployment insurance legislation to withhold the integrity. I mean, it's really about getting the benefits to the people who really need them, who are fired through no fault of their own, and we've seen that eroded, significantly over the years.
Thank you.
And it is a major cost factor for employers.
Other questions for this witness? Not appearing. Next witness. Oh, I'm sorry. Mischief. Representative Weber?
Just briefly inquire.
Go ahead.
I appreciate the difficulty in trying to draw a line between trying to keep people from abusing the system. And I understand every time somebody's in the system, it does cost more money. I get that. And the example you gave about somebody using cocaine and then getting benefits, and I don't know the details of that, but if that's true, then I would agree that cocaine use should probably disqualify you from receiving these benefits. But I'm concerned when I read it. I want, like, for example, it says tardiness.
Right.
So if I take a bus to work because I can't afford a car and I can't afford a cell phone, so I can't call, and the bus is late, and I'm late a couple times because the bus route is late, I can, under that scenario, I would get no unemployment benefits if I was terminated. Is that correct?
If you're in violation, so it says chronic absenteeism or tardiness. So the employer would have to build a case to show that you are chronically absent or tardy. I don't think for a minute if you're tardy for the first day, an employer can fire you and terminate your ability to
Sure,
get
but if the
that
bus is
employment.
late twice in 6 months.
Right, that's a known policy that the employer would have, and that is part of abiding under that known policy.
So if the bus was late twice in 6 months, I could theoretically get no unemployment. I mean, I know that's not the intention, but I'm just saying when you go to court and you look at the law, I mean that's what the law would say, isn't it?
Right. Well, if you look at the statute, it's violation of employer's no-call, no-show policy, chronic absenteeism or tardiness in violation to a known policy. So when you're hired,
Right.
you sit down and you go over the employee handbook, and you have a known policy, you have the policy that the employer puts out.
Right.
If you violate that policy, and the policy usually would set out a number of amount of tardiness and how often, some employers actually, give you so many
I guess
instances before you're terminated.
there's a
But
difference
yes,
between using cocaine, which I think we both agree should be ruled out of the unemployment program, at least I agree,
Right.
and somebody who relies on public transportation and was a victim of a traffic jam or car accident a couple times in a year, and I think those things are very different, and so I just worry that the rule that we're creating here treats both those things the same.
Yeah, and I don't disagree. I agree. There's two complete scenarios between
Right.
using cocaine and driving an 18-wheeler down the highway. I mean,
Right,
it's
which
obvious.
we all agree, and if that's currently being used in the current system, then we should
Right.
find a way to eliminate that.
And there's also a different level of stealing, which we have examples of. Urinating off the school building while the children are in school below. I mean, there are crimes that are.
Which that person didn't get unemployment, is my understanding.
Yeah, no, they did. I'll share the
Okay.
case with you. I think I have it. If I don't, I know
Talk's supposed to
Senator
be pretty
Krause
confident,
does.
but that.
Yeah, and that was actually a case that was ruled by the Department of Labor, not the courts.
Okay. And then I guess the last thing was, I know this was interesting, about if the employee violated a rule or state policy that could require the employer to be sanctioned. I was just thinking about what the scenario of, if I'm told to do something that's illegal, and we pass the whistleblower law so I can't speak up about it with any protections, and then we get caught, and then I get fired, now I don't get any employment. You see how maybe we could have an amendment that unless they're told to do it or something like that?
Oh, you're saying unless they're told to, I think that if they would have just cause to say, hey, I was told to do, I was following my instructions by the employer. But that goes back to the situation with the CDL, the person doing cocaine could no longer perform that function. And if the employer continued to employ that individual, he's violating federal and state laws. So that's what that's talking about.
Okay, maybe an exception for if they're ordered to do something, they're told to do something that violates policy.
You understand this is going in front of referees that can make that decision. Earlier we talked about the definition of chronic. I think that is where a referee can say 2 times being tardy is not chronic. That's, that happens occasionally. I mean, chronic is 15, 20 in a short period of time.
Sure.
So,
Okay. Thank you. I appreciate it, Senator. Appreciate it, Chairman.
To inquire, please.
Go ahead.
Okay. Isn't it true under most companies that drug abuse and alcoholism is treated as a medical issue? under most employees, and they have where they send the employee to treatment for those conditions.
Possibly.
Yeah, because I know, you know, in the large companies like GM, AT&T, things like that, people have those use. So, you know, it's treated as an illness rather than a, so you're saying that, you know, most times they don't get terminated for it. They get, you know, treatment for it.
Well, I think if you go into the employer and say, I have an alcohol problem, I'm an alcoholic, I think that you can go through a treatment program, and I think the employer is going to work with you most of the time. But if you continually not show up at work or are unable to do your job, that's a situation the employer also has to take care of, because they have a job to produce a product or do something in the state of Missouri.
So we're adding this language so that employers don't have to pay unemployment for people that they let go.
That for misconduct. If you
Well, everybody that's let go normally is for misconduct.
right, well, you were here at the opening when I introduced the bill. We have situations in the state of Missouri right now where people that are caught on camera stealing, getting unemployment benefits. I think you and I would both agree that if you were caught stealing from the employer on camera, and that was you, and it was very clear that you were taking something you were entitled to, do you believe that that person should get unemployment benefits?
No, but in other cases, such as tardiness, you said 2 times is not chronic. In my job, 3 times you get put on discipline. 3 times in a year.
That's company policy.
That's company policy. So, and well, hold on. Let me tell you the steps, because when you, in that, so you have 3 times, and then during that time that you're on this 6 months or this 3 months, if anything else happens, you move to a 12-month. And then anything happens in that 12 months, you're terminated for any little thing. It could be doing an order wrong, or you know, being late one more time. So if you say 3 times being late and I'm terminated, you're suggesting that that person shouldn't get unemployment. You follow me? So I'm saying that different companies have different steps, and so when you try to use some language that paints everybody the same, it's not.
Representative, what we're doing is changing definition in statutes. And right now what's happening, our department is, their hands are tied because courts have ruled and pretty much overturned their rulings on a few situations, and everybody's getting unemployment benefits. And that, what we're trying to do is say, hey, that's not the intent of the law. The intent of the law is to provide benefits for those that were let go of no fault of their own. All right? This is a guideline for the department to use. And you mentioned 2 times being absent. I would tell you that I would assume the department would come in and look at chronic.
Tardy.
Tardy being 3 times is not chronic. And because the definition of chronic is not here, but I would think that most people would reasonably say 3 is not chronic. It's not habitual. It's not too big of a problem, depending on the time period that happened in. So this is a guideline for the department to use. It sets the wheel for them so that we can untie their hands, because the court rulings have pretty much said that they've overturned us on all these cases. We've got to go with what the court has done. So we're trying to change the definition so that we can reset the wheel and say some of these situations that got unemployment benefits isn't right, and we need to correct that. And that's what this law, that's what this statute's doing.
I understand that too, but my concern is that, you know, we're going to be that people that shouldn't fall into this will fall into this, because you can't be specific enough. Now, if you had in here saying that, you know, I'm defining chronic as this, and I'm defining, you know, stealing from an employee, or caught doing something criminal, because I think stealing is criminal, you know, those things, those natures, because companies have their own policies. And so I'm thinking that if you were specific in certain areas, it probably would make more sense. Thank you.
To inquire briefly, please.
Go ahead.
Thank you. On this discussion of chronic, these are a guideline. You're saying the employer has rules that they have to follow. They have to know them. When the employee gets hired, when they accept this job, if they have a 3 late times in a year and you're out policy, they've agreed to that policy when they've accepted employment with that company. That's what you're going to, that's what the employer has a right to enforce. If they have rules that say you cannot be late, their job is time sensitive for shift change, amounts of work. You know, when I worked in Chicago, I caught the 7:15 train instead of the 7:30 train to give myself the extra. You know, when you accept employment, if you're told these rules of what your requirements are for what your conduct, your tardiness is, your drug use policy. If they have a drug use policy that says, you know, you use drugs, you're out, no, whatever, isn't that, I mean, that still is in here. Where you're talking about chronic is where that is undefined perhaps in the rules. Where somebody gets, if you don't have a policy on tardiness and the person gets fired for tardy, then your chronic would kick in. Is that the way I'm reading this?
Right, exactly, and thank you, Representative White, for pointing that out. Right, we're not trying to define exactly what the policy should be between the employer and the employee, because as you said, there's different situations. This just says that if you're hired and there is a policy in place, and you agree to that policy, then once you are fired based on not adhering to that policy, that would apply as misconduct, and that can include a lot of things, including tardiness and absenteeism. For those that don't have a policy, there is the guidelines set up that just includes tardiness and absenteeism when it's chronic, and as the Senator said, that will be determined by the appeals judges at the Department of Labor.
Thank you.